Is your name, sir?
Jason Haggard.
Jason Haggard. We'll be on the record in 2026 CR 59, State of Kansas versus Jason Earl Haggard. Marianne Shirley for the state. Mr. Haggard in person, in custody, and pro se. Sir, you are...
This becomes the defendant's main argument. I've never been convicted of violent crimes. And legally, there's an important distinction here. Charges are not convictions. But the judge can still consider prior arrests and allegations when deciding bond and public safety risk.
Charged in count 1 with a pro se, meaning you're on your own without an attorney at this point.
Yeah, I'd rather have an attorney.
Well, we'll get to that.
He's getting there.
Yeah, first thing we're going to do is go over your charges. And in count 1, you're charged with aggravated battery, knowingly causing great bodily harm to another person. We're turning my organization around backwards by bringing you in different orders today, so that's why I'm not quite where I thought I'd be by now. But you are charged with aggravated battery, knowingly causing great bodily harm or disfigurement to another person. That person allegedly being Kyriona Owings. That is charged as a level 4 person felony. And that carries a possible penalty of 38 months up to 172 months in prison and a fine of $300,000 maximum if convicted for this level 4 person felony. In count 2, you're charged with aggravated domestic battery, alleging that on that same date of April 5th, 2026 in Greenwood County, you did knowingly impede the normal breathing of an individual, Kyriona Owings, by applying pressure on her throat, neck, or chest when done in a rude, insulting, or angry manner while having a romantic relationship with the victim. Now, why they've charged you with aggravated battery of the same person and aggravated domestic battery of the same person, I know not. I'm just telling you what they've charged you with. The second count is a level 7 person felony. Penalties are 11 months to 34 months with up to $100,000 in fines. And you are...
Oof, huge courtroom mistake right there. Interrupting the prosecutor while the judge is reviewing violent history. That almost never helps your case. Notice how quickly the judge shuts him down. Courtroom control matters, and patience can directly affect bond decisions.
Are entitled to a preliminary hearing in which the court will hear evidence to determine if there is enough evidence on these charges to send you to arraignment and trial. You are entitled to an attorney to help you through all stages. Are you going to hire an attorney?
No, ma'am, I'm on disability.
All right. And how much per month do you get for disability?
$1,140.
Are you married or single?
Married.
And does your spouse work?
She does.
Where does she work?
It's Kyriona. She works at Pete's.
Okay, but she's the alleged victim, so
Yes.
you won't be living together most likely as a condition of bond. Okay, so do you pay the rent or mortgage to a house?
We both do, yes.
Well, what's your contribution?
I mean, like, I pay half of everything. We pay half. I mean, I pay the electric fully, but
All right.
everything else, like the cell phone, everything, like I don't have money after bills.
Okay. Deputy, can you give him a paper application and have him fill that out?
Yeah.
And then when is the preliminary hearing control, Missy?
May 8th at 1:30.
You must be back here May 8th at 1:30. And I don't believe you've had bond set other than perhaps a scheduled bond. Is the scheduled bond at about 10,000?
It's actually no bond until sees judge.
Okay. Ms. Gillette, does the state have any recommendations on bond at this time?
With regard to this particular defendant, Your Honor, it's my understanding from the officer's calls and the medical records from the hospital where the victim was treated for the ICU and spleen injuries and petechial hemorrhaging and the criminal history.
This is where things get dangerous for the defendant. Prosecutors aren't just talking about the current allegations anymore. They're painting a picture of someone they believe is a threat to the community. ICU injuries, witness intimidation claims, jail calls. That's the kind of combination judges take extremely seriously.
Based upon this, and he has charges, prior things, firearms while intoxicated, failures to appear. It's my understanding that he has not been out of prison or jail that long, but he has a significant criminal history. And while he was in custody, he contacted one of his family members to contact the victim and telling her what to do. This is all recorded on the jail line. So I anticipate he will have additional charging for intimidation of a witness coming.
Can I speak, ma'am?
Not yet. Don't interrupt. Go ahead, Miss Shirley.
And he may, in fact, we have a significant criminal history of violence.
I have 0 violent crimes.
I said don't interrupt. Stop talking. Go ahead, Miss Shirley.
Like I said, I'm just flipping through his criminal history record. He's got all kinds of priors for obstructing, failures to appear, aggravated assaults, and I don't have the certified.
Did you catch that? Even the judge seems confused about why prosecutors stacked both aggravated battery and aggravated domestic battery for the same alleged incident. That's the kind of detailed defense attorneys love to challenge later in court.
Documents yet on all of them, but I think that he poses a significant danger to the community. I don't know that he has anywhere to go when he is out. I am presuming if he's recently released, he's probably on some kind of supervision, and this charge would in fact vitiate probation or parole or whatever he is on. I don't believe that $100,000 would be out of line in his particular case.
I'll give you a chance, Mr. Haggard, to speak, but before you do, I'm just pulling up what my Odyssey system shows of your criminal history in Kansas. Going back to 2006, there are 21 charges in that case alone. I don't know, 2, 4, 6, 8, about 8 of them are ag assaults. There's a list of them that are misdemeanor assaults. There's another aggravated assault, ag battery, criminal damage to property, unlawful assembly, disorderly conduct. And then we go to 2009. I'm not sure what that's all about. It's just not clear to me. But there is one that has obstructing legal process in a felony case. We have a 2009 domestic matter, a couple of those, traffic, and then we have in 2011 a big list again of maybe up to 13 different counts, thefts, interference with law enforcement, multiple counts of that. And it goes on. Possession of opiates, opium, drugs, battery of a law enforcement officer done in a rude manner. In 2020, there's a criminal threat. driving under the influence. 2011, some things going on with traffic, unsafe turning, failing to yield. 2013, violation of a protection order, and that's not one of these. Looks like in 2025, Sedgwick County filed a stalking charge. So, Mr. Haggard, I don't know how much of this is genuine or not. You're welcome to address it, but I would caution you that your attorney's not going to want you to say anything that could get you into deeper trouble.
All I want to say is I've never been convicted of any violent crimes. Period. I've only besides maybe a misdemeanor, I have no aggravated charges on my history at all. This is the first time I'm dealing with violent crimes. I usually have I have a drug history. That's where all my trouble comes from. Never had any.
Right away, this hearing takes a sharp turn. The judge notices the defendant is representing himself, and in serious felony cases, that's usually a massive red flag. When aggravated battery charges enter the courtroom, every single word can come back to haunt you later.
Violent crimes that I've been convicted of, any felony, anything like that, aggravated, ever. So I was sitting there just shaking my head like, I don't know where all this is coming from, but that's not true.
Well, it does look in the 2006 CR where you have 21 charges: ag assault, ag battery, criminal damage to property, unlawful assembly, disorderly conduct, assault, 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 assault. Then come the aggravated assault, 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 aggravated assault. I understand where you're coming from, because it looks like what I typically see when a plea bargain is entered, where you plead guilty to some of those charges and then the rest are dismissed. So I think that's what your point is that you're making. Is that right?
Yeah, I've never been. Yes, I've never been convicted of any violent ag anything. Like I don't.
Now,
That's
here,
not mine.
this 2009 obstructing legal process in a felony.
Because I was on a felony case, and
Okay.
it was a felony since I was on a felony warrant.
All right. Well, in any event, it says there was a guilty plea and you were convicted of that.
Yeah, I did my time for that.
Okay. And
I had just come out of a coma like months before. Like I have a traumatic brain injury.
All right. Well, I would agree that $100,000 bond is not unreasonable, and that will be your bond. But talk to your attorney, and we can revisit that issue. And we have not determined an attorney, as I recall, is going to have you fill out the paper form for that. And when the jailer gets that back to me, then I can tell you who your attorney is, if you have an attorney. And it sounds like you will have, if what I heard from Miss Shirley was right. And when is his court date? You said May. We're using May what?
May 8th at 1:30.
Be back here May 8th at 1:30 with your attorney ready to go. But we can move that up if we need to revisit the bond issue.
There's nowhere.
Any questions for me, sir?
No.
All right. Well, thank you. We'll see you later on these charges, but get that form filled out and back to me as soon as you can. Okay. Does that bring us
Sorry, I interrupted. I'm sorry.
No problem. Go ahead.
I was going to say that I have to get the female, so if you want to take up another case, you can.
Okay. Thank you. I appreciate the permission.
Sorry.
I know what you meant. Thank you. All right. Bradley Becker, are you here?